All right, welcome to today's edition of Chuck TV, the official Sovos podcast around sales and use tax. We're here today with Chuck Maniaci, the head of regulatory analysis here at Sovos, and it's Chuck, a very exciting day for us and for sales tax in the U.S.
Eric, it's good to talk with you today. It is perhaps not understated that it's the most exciting day in sales tax probably in the last 20 plus years.
Wow. So we want to just talk a little bit about it now. There's a lot to process here, and we'll be doing a lot more coverage over the next few weeks here, but wanted to give everyone a quick update from your perspective on how things are going. And in particular, just give us the high level here, Chuck. What does this change for businesses in the U.S.?
Sure. So this really does change everything. Essentially, in their ruling today, even though the case was technically remanded back to the South Dakota court system, the Supreme Court has overruled the Quill Doctrine and its predecessor, National Bella Hess. And those two cases formulate the proposition that physical presence is a prerequisite to a sales tax collection and remittance obligation. So today, it is no longer the case that states are precluded from imposing sales tax on sellers that are economically connected with the state. That barrier, that bright line rule of physical presence doesn't exist anymore.
Right. So if it's not physical presence, what is it?
Okay, that's a good question. The court was very careful to say that it's not a complete and total free-for-all. There have been other cases, and not to get too legally, one of them is complete auto transit, and the other is Pike versus Bruce Church. And in both those cases, the Supreme Court talked about how state law can be evaluated against whether it's an undue burden of interstate commerce. And in both those cases, it's more of a fact-intensive inquiry that requires you to consider like all the circumstances surrounding the law. And rather than having a bright line rule now, each state's law, at least for now, will be evaluated against the entire backdrop and circumstances around it to see if that law in particular is or is not an undue burden. The court was very specific to say the South Dakota law, which as you know, places this obligation on vendors that have 200 or more individual sales or $100,000 or more in transactional volume. They were very careful to say that this rule, based on the way South Dakota works, is not overly burdensome. So states with similar tax regimes to South Dakota and states with similar rules would likely get a similar result if they pass an economic nexus law.
Right, and I think there's at least a dozen states out there that have similar kind of economic nexus rules out there. What can we expect overall from the states here in the next few months, or what should businesses expect?
Yeah, so you're right. There's a lot of states that in the intervening years, since a couple years since this case was first started to be litigated, that they passed a bunch of rules, state passed laws that said should South Dakota prevail in their economic nexus litigation. So in other words, they didn't want to necessarily get involved in the litigation themselves, but they wanted to be immediately ready should South Dakota win. They've enacted these similar economic nexus rules with somewhat similar standards, and they said in their law, this rule will take effect if and when the Supreme Court decides in favor of a litigant for economic nexus. So technically, in a number of states, these laws come into effect today. Now, whether these individual laws likewise pass Commerce Clause muster will be a story that has to be decided state by state by state. So what we'll likely see is we will see other states enacting economic nexus standards that mirror South Dakota's, and B, we may see litigation in those states that already have challenging whether or not their particular rules pass constitutional muster like South Dakota's does.
Great. So a lot still to be figured out here, and a lot for businesses to keep track of. So if I'm a business that is using e-commerce to sell into some states where today I might not have physical nexus, but under this standard or set of standards, I might now have economic nexus. What can I be doing today to prepare?
Yeah, well, hopefully. So we've been talking a lot about how sellers should be preparing and thinking about this over the last 6 months or so. We've been certainly uh, sounding that alarm or raising that alert. Hopefully, some e-commerce sellers have indeed uh, accepted that challenge and have started to get themselves ready. If you haven't, you absolutely need to start doing that now. You need to put processes in place where you will ultimately have the ability to take a current limited economic nexus footprint and turn it into a scenario where you can accommodate a much larger, actually a physical presence footprint to an economic nexus footprint. You have to be ready now for sure to face a situation where you have an obligation in many more states than you did just yesterday.
Right. I think one of the things that the ruling talked quite a bit about is the use of software to prepare for that. How prepared do you think software companies like ours are for the standards that are laid out in the ruling today?
Well, we've been seeing this coming. We've been waiting for this day for the better part of a decade. I mean, Sovos, for example, we've been a participant in the Streamlined Sales Tax Initiative from the very beginning. And while Streamline, of course, is primarily primarily tasked with simplifying rules, obviously in the back of everybody's head from the very beginning was creating a landscape where sales tax isn't as big a burden as it was in the past and becomes manageable. Part of that comes from simplification, creating rules that are not impossible to comply with. And the 24 member states of the Streamlined Initiative have done that, including South Dakota, and also creating and maintaining software solutions that make sales tax compliance affordable. Now, of course, in the member states, there's options for free software that's paid for by the states. But really, what the Supreme Court was careful to say is that there is affordable software solutions out there today, and in fact, they're likely to become more affordable based on the change in the economic landscape created by this decision.
Right. And, obviously here at Sovos, we have solutions both for the large enterprise that are in compliance with this as well as small businesses. So, I think this is good for us and good for our customers potentially to kind of push all of that forward. So Chuck,
Eric, actually, yeah. It was interesting. As I was reading the opinion, and of course I want to read it again, and I want to read all the separate concurrences and dissents, because this was a very close, this was a 5-4 decision by the court. And I was very pleased because on the hyperbole of both sides, there was discussion about the affordability of software. So, with the most vociferous proponents of South Dakota saying that software is free, and the most vociferous opponents saying it's ridiculously expensive. The fact is, it's affordable based on the size of your company. Smaller companies can adopt solutions that are extremely reasonable and manageable to use, and larger enterprise businesses that could afford it can adopt enterprise-level software that makes it affordable for them too. So, in fact, I believe in the majority opinion, they used the phrase affordable, and I was super pleased to see that.
Right. It's matched to the needs and complexity of your specific business.
Exactly.
Right. Good. So one last question to finish us off, and obviously a lot more coverage on this coming up here soon. But Chuck, if we finish the sentence for me, in 5 years, if we look back on this ruling, we'll say what?
It was a day that lived in infamy. All right. So maybe, Eric, that's hyperbole. Maybe that's a little too much, but for those of us in the sales tax space, and today I'm at a conference with other sales tax professionals, and the excitement is palpable. Uh, and really, I think we'll view this as the day where everything changed.
Right.
That the foundation was shaken, and that we're going to build a new set of sales tax rules that are reflective of the digital economy and not a bygone era.
Yeah, it's a great point to end on, Chuck. It's certainly something, as you know, we talk a lot about here at Sovos. We believe our purpose is to reduce the friction between business and governments. It's been a problem for a long, long time. Tax, it's hard on businesses because the rules are confusing, hard to comply with, and lead to a lot of risk. Really hard on governments because they don't get the money that they're owed. And so certainly your point there, a day that lives in infamy, a day
Yep.
that allows us to finally come to some kind of agreement that makes this all easier. Hopefully this is a path to that. So Chuck, thanks for the time today, and look forward to talking to you more as this all progresses.
Talk to you soon, Eric. Nice talking to
Thanks.
you.